instruction 27.
Yes, sir.
Anything on behalf of defendant Perez?
No, Your Honor, those are my only comments.
Brings us to 28, unlawfulness.
Your Honor, again, it refers to aggravated battery as charged in count 2, so that needs to be changed. Other than that, I think we're okay with this one. We are okay.
No additional comments.
And this, I went in a different order than I wanted to go in because I was working from the state's modified instructions as opposed to the jury instructions as I laid them out. So I just want to back up a little before we got into the aggravated battery. So we have 211 agreed to. I'm making modifications as far as, I think in some of the instructions, you capitalize the crime. They should be lowercase. So when you're looking at the final draft, I'd like for you to look at that, make sure it's consistent.
Yes, Your Honor.
So we have 211, we have the definition of great bodily harm, approximate cause. And then let's jump to justifiable homicide by a public officer. Is the state opposing that instruction?
Yes, we are, Your Honor.
Solve your argument on that.
We would oppose giving this instruction altogether because there's been insufficient evidence to show that the killing was committed while overcoming the actual resistance of James Boyd to the discharge of the legal duty to arrest him. You heard testimony from defendant Perez, who explained his understanding that the fact that a person can't leave, that means they're under arrest. And what we saw yesterday during the cross-examination of defendant Sandy was that Mr. Boyd was told multiple times, including 5 times in the last 15 or 20 minutes, that he could come and walk down the hill with all of his belongings and that he would not be harmed in doing so. He was never told he was under arrest. And it's not about the officer's perception of whether the defendant should be under arrest or whether the officer is arresting him. The test for whether a person is under arrest is based on the suspect's or the arrestee's perception. And United States versus Mendenhall, 446 U.S. 544, holds that a person is arrested if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. And again, Mr. Boyd was told multiple times that he was going to be able to leave without being taken into custody. He was never told that he was they had committed a crime, and for that reason, the state's position is that element number 3, which is essential to giving this instruction to the jury, has not been met. And if this instruction is given, we would also ask that Your Honor accept our version of the jury instruction, which tracks the UJI, whereas the defendant's proposed jury instruction deviates from that quite substantially.
Anything more on that instruction?
No, Your Honor.
Okay. Who wanted to respond first?
I'll go. Your Honor, first of all, as you know, if there's any evidence whatsoever to support the giving of the instruction of this nature, it must be given. I would note that the defendant, or that the person shot in Mantelli was never specifically told he was under arrest. Rather, the circumstances made it clear that he was not free to leave. Similarly, I think that this is a gross mischaracterization of the actual events where Mr. Boyd was told numerous times, you cannot come down until you put down the knife. It's a selective taking of certain things that were said rather than an understanding of the totality of how this arose. When people move in to take you into custody and you pull out knives, that is certainly actual resistance to what is being done pursuant to the law, regardless of whether he's told he's under arrest. Whether a reasonable person would believe he was not free to leave. And so in Mendenhall, it does say that examples of circumstances that might indicate a seizure, even where the person did not attempt to leave, would be the threatening presence of several officers, the display of a weapon by an officer, some physical touching of the person of the citizen, or the use of language or tone of voice indicating that compliance with the officer's request might be compelled. We certainly have that here, and there's sufficient evidence to go to jury. And I would also say, obviously, we want our version to be given because the case law strongly supports it, as we've briefed extensively.
Anything else?
Yeah, I don't have much to add to that, other than we heard audio tape yesterday of Officer Weimerskirch telling Mr. Boyd, I think several times, you gotta come down, you're coming with us. For several hours, a reasonable person would not have thought that they were free to just walk away under these circumstances. And certainly, as Mr. Roman pointed out, so for hours, he meets that definition of being under arrest. In the seconds leading up to the actual shooting, taking out the knives, all of that, surely means that little burden of that the jury should be instructed that he was actively resisting arrest.
I think there's overwhelming evidence to support this instruction going to the jury. I'm surprised at the state's argument with regard to the evidence that they put on without an arrest plan, about 19 officers on the perimeter. So clearly this instruction is going to the jury. Let me get to the state's latest version of this, which is 38.
30. Yeah.
Okay.
38. And I understand the defense has an objection to the state's proposed paragraph 3, as it doesn't include enough detail, yet the state opposes the defense's version. And I'm just going to tell you how I think it should be based on the evidence that was presented, and also based on Mantelli. And what I'm referring to is paragraph 22 of Mantelli. Where the court's talking about the proper application of the reasonableness standard requires careful attention to the facts and circumstances of each particular case, including severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. Keeping that in mind, I think paragraph 3 should read that the killing was committed while overcoming the actual resistance of James Boyd to the discharge of the legal duty to arrest James Boyd for the felony crime of aggravated assault on a peace officer. So any objection to it reading that way?
None for Sandy.
No, Your Honor.
Anything from the state?
Yes, Your Honor. Paragraph 22 of Mantelli is referring to the background as to why this statute was amended in response to Tennessee versus Garner and Graham versus Connor, and it was addressing excessive force claims brought against police officers. As Your Honor has noted throughout this trial, the objective reasonableness at issue is whether the officers perceived or believed that Mr. Boyd was a threat. It's not about the objective reasonableness of their use of force. And so I think that this paragraph that Your Honor is citing is not relevant to the discussion. As far as including all the circumstances, I think that doesn't track what the UJI provides. I think that ours is closer to what the UJI says as drafted by the New Mexico Supreme Court. And if we're going to start including all of the circumstances, I think that we should also include some of the other circumstances that were that influenced the officer's decisions, such as the fact that the officers closed the distance rather than Mr. Boyd. But I think that's a slippery slope, and we should just stick to the UJI.
Right, but this is the bracketed portion where you fill in how the facts of the case apply to this element 3, paragraph 3. The killing was committed while overcoming actual resistance of, you fill in the name of the victim, James Boyd, to the discharge of, and then it's blank, and you have to describe the legal duty. And I think that my suggestion does that.
I would just add, Your Honor, that the blank is under the legal duty to arrest him, and then for argument, defense can argue he had committed the felony crime of aggravated assault against a peace officer, but the legal duty to arrest him is sufficient to fill in that blank.
Okay, well, I guess I disagree because they could have been trying to arrest without the legal duty, and the fact that they observed the felony committed in their presence satisfies them. So that's why I'm going to leave it the way I suggested. I know that this is really nitpicky, but if you look at the UJI, it has paragraph 1 that describes the element, there's a semicolon and the word "and." And there's paragraph 2 and a semicolon, and there's not an "and." And then there's paragraph 3 and there's a semicolon and there's an "and." So I just wanted to point out that it looks like the UJI left out an "and." So does anyone have a problem with me adding the "and" after paragraph 2?
No objection.
After paragraph 2, you said, Your Honor? No problem at all with that. Thank you.
No objection.
And moving on to 5172, which
Yeah.
is the less broad defense, which is defense of another.
Before we move on,
Okay.
I just want to make it clear that another distinction between Officer Sandy's version of justifiable homicide by a public officer in the states is where the state uses reasonable person, as is in the UGI admittedly. We use reasonable police officer. I understand the courts,
I'm following the UJ.
and I understand that. I just want to make sure that we make our record. that-
Sure, and if you want to add more, it's probably a good idea to do it now.
Okay. Your Honor, as set forth in Mantelli, it is not a reasonable person that would be a regular citizen on the street. I think it's important that the jury be instructed that a reasonable police officer is the standard by which these officers should be judged, because the duties of a police officer and privileges of a police officer are so different than a member of the general public.
I would only add, Your Honor, I certainly concur with that. Would add that Ellis, which was adopted after, or which came after the UJI was published, adopted the reasonable officer standard and included with the same training and experience as the officer. I think whether it's a reasonable person or reasonable officer, it's with the same training and experience that's really the essential part to get in there, because that is what captures the under the same circumstances. And that is the language that was adopted by Ellis.
Isn't that something that can be addressed through your closing argument and how the facts should be applied to the law?
It will certainly will be addressed in the closing arguments. I think that to be complete, it should be in the jury instruction. That's our argument.
And what I'd like to do is get through basically the skeleton, the bones before, and I know there's other instructions that aren't UJIs that have been requested by defendants. I just want to get the structure in place and then give you a chance to argue those other instructions.
Okay.
All right, so moving on to 5172. This is, I'm not sure, let me try to find the state's number.
37.
37? Is there any objection to the state's version on number 37? I think we have, the area of discussion is going to be in paragraph 1, because initially there was an objection to, I believe it was Defendant Perez's language about close proximity.
Yes.
Correct, Your Honor.
And their current version states, there was an appearance of immediate danger of death or great bodily harm to another officer as a result of James Boyd's actions.
That's the state's current version, Your Honor. I don't know that.
I don't know if I said defendant, but I meant.
Right.
Yes, Your Honor, I believe that in the current version, my understanding is that in paragraph 1, we're still supposed to put in some information about what was done, and that's why we suggested that there was an appearance of immediate danger of death or great bodily harm to another officer as a result of explaining what Mr. Boyd's actions were.
Right.
And that would be our objection, is that it needs to go further than that, explain what those actions were that created the appearance of immediate
My
danger.
thought was, as a result of James Boyd removing knives from his pockets during the execution of an arrest plan, which is what the state has presented.
We're fine with that.
Your Honor, I guess my concern with that then is that it sort of closes the universe of what James Boyd's actions were. And while that certainly is a big one, there were all the threats and everything leading up to that. It was also in the officer's minds, I think, when this happened.
So what are you proposing?
Your Honor, I just want to make sure I'm on the same page, because when I was looking at states, what I have is states 37, I didn't have that additional language in there, and I thought you said they had proposed it.
No, they didn't.
Oh, you're saying you're adding
I
that?
said based on what they proposed and then the point that you made.
Okay.
It seemed like the evidence certainly shows that James Boyd removed the knives during the execution of the arrest plan.
And we're okay with that.
I would just add, Your Honor, that James Boyd's actions, it's what Mr. Logan is referring to. They can, in closing, argue whatever actions they want those to be, and we can argue whether or not his actions justify or, created this reasonable belief that the officers were in immediate danger. So it's unnecessarily limiting, and James Boyd's actions is broad enough and descriptive enough that allows the defense to argue whatever they want about his actions and what they caused or didn't cause.
Your Honor, I'll withdraw my objection. I'm fine with what you proposed.
I don't think the state's version is specific enough. So I do think the evidence supports, the state's objection to what was proposed by defendants was the close proximity. And I think that's a question for the jury as far as how to define close proximity. So I think my suggestion addresses the vagueness of the state's proposed instruction or element one, and balances with the defendant's, or the state's objection to defendant's request to say close proximity. So I'm going to give the jury the instruction with the action being removing knives from his pockets during the execution of the arrest plan, because I think clearly that's what the facts show.
I'm sorry, Your Honor, can you just read it one more time?
Sure. And I will give you a copy of
Okay.
all of this. So
I
what
just
I'll
wanna-
do is we'll run through this, we'll have a discussion, I'll make the changes that I think are appropriate. I will print these and then provide copies to all of you to review. I want you to see if there are any typos or mistakes, and then when you feel confident that they're in a good final form, then we'll proceed.
Thank you, Your Honor.
So the language is that, and this is paragraph 1 of 5172, there was an appearance of immediate danger of death or great bodily harm to another officer as a result of James Boyd removing knives from his pockets during the execution of an arrest plan. Were there any other concerns about any of the remaining portions of that instruction?
No, Sandy.
No, Your Honor.
And so back to, I think then we'll cover aggravated battery. I know we talked about it. I just want to point something out for the record, that in the original form, the third element under 14.322, aggravated battery with a deadly weapon, the state proposed defendant's act was unlawful. Rather than stating defendant's act was unlawful, I think we should replace it with the defendant did not act, let me rephrase. The defendant did not commit justifiable homicide by a public officer or employee, or act in defense of another. Again, putting the broader protection defense before the less broad defense.
That's fine.
I think that our concern with that is the unlawfulness instruction, our number 28 would seem to cover that already. It says for the act to have been unlawful, it must have been done, I'm sorry, I'm looking at the wrong paragraph. Aggravated battery does not include a touching for purposes of lawful arrest, search, or confinement. and that could be modified to reflect what you're proposing, I think, but I think for the elements of aggravated battery, we should stick to the UJI.
Well, I am sticking to the UJI as I understand it, because 14-132 unlawfulness, which is your 28,
Yes.
this instruction doesn't need to be given according to use note 1. This instruction need not be given if the unlawfulness element is included in another instruction, such as defense of another. So I think that what I'm proposing conforms with the UJI instructions.
I'm sorry, and does that mean that states number 28 would then just come out?
Right.
So can you please read back what you want to add into the aggravated battery?
How aggravated battery is read?
Yes.
You want me to read all?
Just that portion that you're modifying, Your Honor.
Well,
And I'll tell you my concern is
Well,
that,
let me read the 4 elements that would be in the instruction. The defendant touched or applied force to James Boyd by shooting him with a firearm. The defendant intended to injure James Boyd. The defendant did not commit justifiable homicide by a public officer or employee or act in defense of another. And this happened in New Mexico on or about 60 days, March 24th.
so Your Honor, my concern is that in the UJI that you're suggesting we remove, states that aggravated battery does not include a touching for purposes of lawful arrest, and I think that needs to be in here. I think that if we're taking that out, I think it should also be added into the aggravated battery elements instruction.
It is by defining the defenses, identifying the defenses that make it lawful.
Okay.
You understand what I'm saying? It was not done as justifiable homicide by a public officer or in defense of another.
And you think that, and you're saying that the jury would assume that that also means not for purposes of a lawful arrest?
If they find that.
I just think it should be added in.
If they find the lawful arrest, overcoming resistance to lawful arrest, then they found justifiable homicide.
Okay, fair enough.
But that's if they perceive that the threat was justifiable.
Your Honor, I would just note that Defendant Sandy objected to including state's proposed instruction number 28 at all.
Sandy and said as
Well-
opposed, I don't know what their specific objection was.
I think I objected to the original version of that, which did not, and I may be mistaken, but I don't think the original version included that last paragraph about lawful arrest. Is that right?
So let me take
No, it
the-
did.
My concern, Your Honor, is just to be
Wait,
with.
wait a second.
I'm sorry.
So let me just restate this portion that I'm addressing and then see if we're all on the same page or not. Use note 1, if this instruction is given, which is the unlawfulness of an element, add to the essential elements instruction of the offense charge, the defendant's act was unlawful. This instruction need not be given if the unlawfulness element is included in another instruction, such as self-defense or defense of another. And then it references the options that you have. That's why I don't think it's necessary. If you identify defense of another and justifiable homicide by cause. So, Ms. Montoya, did you? You started to raise a concern, but I was reading, so I wanted you to weigh in.
Yeah, and I think I understand.
We can look at that.
And Mr. Roman?
I'm sorry, we don't have any objection.
Your Honor, would we modify states number 27 the same way with unlawful?
Yeah, paragraph 4 would be the same. The defendant did not commit justifiable homicide by a public officer, employee, or acting defense of another. So, any more discussion on 26 and 27?
None for Cindy.
No, Your Honor.
The next one to address then is general intent. That's page 29. Any discussion about that? It looks like it's straight from HAI.
Nothing for Cindy.
No, Your Honor.
That brings us to, I think that brings us to 6012 and 6010, the general verdict. Starting with 6012. I was a little confused about this because there's a use note that says in 6012 that it shouldn't be used where there's homicide charges. I think that's in cases where there's multiple theories of homicide, as opposed to where there's a homicide and then some other lesser included that's not homicide. So I think the state is right that it's 6012 that should be used. Any discussion about that?
Yeah, we have proposed a form of the UJI 250, which is a step down from second degree to aggravated battery. That's the one that we think should be used. If you'd rather use this framework, I have some pretty serious concerns with how states 45A have been drafted.
Let me get to 45. Okay.
There are portions of this that are bolded and italicized, and maybe that's just to show what was being added.
That's right.
If we're all in agreement that nothing is bolded when it goes to the jury, then that.
And actually, the charges shouldn't even be capitalized, just second degree murder, lowercase, aggravated battery.
Okay. So that takes care of my, well, that may be all of my concern. But I would point out that the title of this instruction is multiple verdict forms, and that will segue into my concerns for the state's verdict form when we get there.
Okay. Let me just review this. discussion about 45B then as it relates to 146010 and defendant Perez?
Only the capitalization issues, Your Honor, but other than that.
Was that just to show that the entire thing was a new instruction?
Yes.
The bolding, that's right.
The clean copy does not have any of the bolding.
And I'll be doing the clean copy. I just think it's going to save time.
And the clean copy does still have capitalization, so,
I'm taking care of all of that.
right, and we'll double check too when you give us the chance.
That'll be helpful.
Thank you.
Then we get to 6020, which is the final instruction. I don't know if you all remember or have tracked it all with regard to who the alternate jurors are, but I have 65 and 93.
I'm sorry, Your Honor, I wasn't able to hear.
Alternates are 65 and 93. 77 replaced 30. That was the woman who was talking about the case with her daughter. We lost, I think it was alternate number 2 because of a conflict in schedule. So that leaves us 65 and 93 as the alternate.
And I didn't bring that with me, but I have a photograph that I took when you passed it out, so if I'm not texting, I'm just going to check my photo.
I have 89 and 93.
I don't have an 89.
Oh, I think the problem, Your Honor, is that there are two 65s perhaps on your form. And I don't want to say the name, but the one who's,
Can you come up and?
yes.
I have the names on the numbers. Yeah. Here is the numbers. Yeah, so this is actually good. I don't know if you. I've highlighted.
All about whether an officer's use of force was excessive, and that's as Your Honor has acknowledged throughout this case, that's not the issue here. It's not about whether the officer's use of force was reasonable. It's about whether the officer's belief was reasonable about the perceived threat. Just most importantly, this would simply confuse the jury. It's duplicative of 5173, and it's just totally unnecessary. The defense is free to argue this. It's been presented in the SOPs, but it's not appropriate for a jury instruction.
Okay.
I would just add that if you're going to give the UJI unjustifiable homicide worded as a reasonable person, not a reasonable officer, then the jury should be given this. This instruction helps define what a reasonable person in those circumstances would be.
I think this is covered in 5173. And the reasonable person in the same circumstances can be argued with regard to the officer's training and experience and the situation that they're in these rapidly evolving situations. I also think it has potential to confuse because it relates to a choice with regard to use of force, which is not an element. So that's why I think 5173 covers this. So that's with regard to Defendant Sandy's proposed number 5 and Defendant Perez's proposed number 8. Moving on to 9.
Moving on to 9, Your Honor. I think the argument that the state just made and has been making throughout about how the arrow only goes one way and that the way in which the situation occurred is relevant to whether a threat existed or not makes number 9 essential, because the state's theory is essentially trying to punish these two defendants for other officers attempting to effect a legal arrest that they were obligated to do. And this instruction is necessary to explain why the other officers were not only allowed but obligated to effect an arrest. While it's taken from Alana's and State versus Vargas, and I can imagine the state's going to say those are old cases, those are pre-Graham cases. Those two cases are explicitly referenced and cited heavily in the Ellis case from 2008 for these very propositions. So in order for the jury to be able to understand these circumstances and evaluate the circumstances, this instruction needs to be given.
Your Honor, Defendant Perez's instruction number 9 is similar to Sandy's instruction number 3, which we submitted. Ours is a little shorter. And if I understand your ruling on the Graham versus Connor instruction, I think my version, Sandy's 3, would address that concern, which is we don't want the jury to be confused with what is a reasonable use of force. But mine also tracks Alanis versus Funk and instructs the jury that the police officer has a duty to use a reasonable effort to apprehend a felon, but does not talk about what a reasonable use of force should be. So, Your Honor, if you have that concern with this instruction, as you did the last one, I suggest you use ours, and I think that would take care of that concern.
Your Honor, this instruction seems to be designed for a civil case. It's based on Alanis v. Funk, which is a civil case from 1961, which, as Mr. Roman pointed out, is before Tennessee versus Garner and Graham v. Connor. And it's certainly not the law that, in this case, that officers should not be held liable for attempting to perform their lawful duty as long as the force that they use is reasonable. This is not about being held liable. That's a civil term, obviously. I point out that Defendant Sandy's instruction number 3 says the same thing. And this is duplicative of 5173 again. Element number 3 talks about resisting a legal duty to arrest. They put on testimony that they had a legal duty to arrest, and it's not the role of a jury instruction to argue their case or remind the jurors about that testimony. And so we would request that you deny this instruction as well.
And what?
I would just say that I now, with your prior rulings, do understand a concern about use of force creeping in, and so we would, Defendant Perez would agree to Defendant Sandy's number 3, which does address that concern.
Not exactly. Duty to use every reasonable effort. It wasn't a reasonable effort in the minds of the jury. I think it'll be confusing. So it's covered by 5173. Number 10?
Yeah, I think number 10 can be withdrawn because it's been sufficiently from. I think.
Yeah, I think you have the factual testimony from the witnesses. It didn't seem necessary to multiple.
And because the court split it into the elements, we can
Right,
withdraw.
and element 3 of justifiable homicide.
Right.
Yeah, my concern is that in opening, the state still trying to advance this thing that all this happened because the poor guy was camping without a permit.
That's a factual distinction that you can make. That all the witnesses have testified that was the purpose of the original call, but the actual response was triggered by the aggravated assault. And numerous witnesses identified the action as an aggravated assault, and that's why he was being arrested.
But as a statement of the law, that is a felony. And when we get back to justifiable homicide instruction, I think it talks about.
There was no evidence that it wasn't a felony. All the testimony was that it was a felony offense.
Okay.
I know you weren't here, I don't know if you were watching it.
No, I understand what the testimony has been. My concern was that the statements made in opening would confuse this issue. I understand that, believe me, I'm quite aware that all the evidence was clear that what was said in opening was not the case.
Well, I don't recall the opening, I just know that what the evidence showed is that the initial response was the ordinance violation. And then the bigger response was triggered by the felony offense of an aggravated assault on public property.
That's fine.
So I don't think it's necessary. I think the evidence, you can argue what the evidence shows. 11?
I think with 11 and the way that the instructions have been given and all the talk in 11 about use of deadly force versus what the elements are, it doesn't really have a place. So we would withdraw 11.
Anything for the record, Mr. Lynn?
Yeah. Your Honor, that instruction, Perez's instruction 11, is virtually identical to Sandy's instruction 2. I think it should be given.
All right, so let me focus on Sandy's instruction 2. Let me hear from the stage.
I'm sorry, did you say the state?
Yeah, on the proposed instruction by defendant Sandy, that's marked as number 2.
Yes, again, this is duplicative of 5173. The first paragraph where it talks about a wider scope of privilege.
No, I think you're...
Oh, yeah, okay,
Yeah.
so that's essentially covered in 5173. The 5173 represents the wider scope of privilege that we're talking about.
It does.
And I don't know if you want me to go any further. I just think this is already covered. And it will just confuse the jury.
It is covered by 5173 in my opinion, so I'm going to deny the request for defendant Sandy's proposed jury instruction number 2. And the record is reflecting that defendant Perez's proposed instruction 11 is withdrawn. That brings us to defendant Perez's proposed instruction 12.
Yes, Your Honor, and this goes directly to element number 4 when we're talking about the reasonableness of perception of a threat and degree of threat. As we've discussed throughout, Ellis has incorporated the idea of some of the concepts that have evolved in assessing the Fourth Amendment in the civil context, has adopted those to be considered in the criminal context. And this instruction, which helps jurors assess the reasonableness of a degree of threat, comes down from a long line of cases that define what is reasonable when perceiving a threat in this very type of situation. We're asking people to put themselves in the position of a reasonable person in assessing this sort of situation without giving them any guidance as to what's reasonable to consider and what isn't. And this instruction clearly lays out exactly what sorts of things are relevant to consider in assessing a threat. And so because it goes directly to the elements, it's not arguing the state's or the defense's theory of the case. It's only explaining, giving a little bit of guidance on what one of those elements is.
Mr. Long?
Your Honor, I concur, and I have nothing to add.
State?
Your Honor, this is just argument about what the defense believes is relevant to the totality of the circumstances. Mr. Roman argued that this would help the jurors assess the reasonableness of a threat. I think we've heard lots of testimony about what the officer's training was, what the officers perceived at the scene, what they saw, and that is what will help them assess the reasonableness of the threat in the totality of the circumstances. If we're going to list out everything that the jury should consider in assessing the degree of threat, we should list out every single fact that's come in. The fact that these officers closed the distance as opposed to the other way around. And I would just point out that this is based on another civil case that is not applicable. Again, Ellis, the fact that Ellis, State v. Ellis incorporated that case or civil standards has nothing to do with this, since Ellis was not a justifiable homicide by a police officer case. And we would ask that you deny this one as well.
May I respond briefly, Your Honor?
Sure.
This is talking about assessing degree of threat, not about whether force used was reasonable or not. I certainly get the distinction in some cases that are talking about, is the use of force reasonable? This goes directly to assessing the threat. And it's not like this list is hand-picked of things to consider and not consider. It's interesting that the state talks about, well, it should also include whether they close the distance. Well, that's not what the case law says to include. These are the only elements of concluding whether there was a threat or not that has been listed in the case law as laid out. And so it's not our view of what is relevant and leaving some others out and adding the ones we want. This is coming directly from the case law, as these are what to consider when assessing the degree of threat, which is exactly what the jury is called upon to do in this case.
And, Your Honor, this comes from a civil case regarding excessive force. This is not a statement of the law. It's argument about what the jurors should consider in applying the law. And the jury instructions should simply tell the jurors what the law is, and that doesn't include what some courts have said about what's to be considered in a civil case of excessive force.
Okay. I agree with the state. I think that's everything on Defendant Perez's instruction.
That's it.
And Mr. Lohman, one thing that I noticed in instruction number 1 for Defendant Sandy was it seemed that in paragraph 4, it included death or great bodily harm to Keith Sandy or another person. Was that an error? It was my understanding that it was defense of another, not concerned about Defendant Sandy's safety.
You're right, Your Honor. That should. Yeah.
So it would just read threat of death or great bodily harm to another officer?
Correct.
Or person?
That would-
person.
Another person.
A person.
I think I was tracking, well, I was tracking the UJI, which includes a blank for name of defendant or another person, but considering the facts, I'm okay with that change.
I actually have it in the instruction as okay, I have it as person. There's one instruction that I remember from the state that we didn't cover. But no one told me I missed it. Instruction 34, limitations, aggressor.
I didn't hear that, Your Honor.
Limitations, aggressor, it's number 34. Oh, yeah, we did, because we did it 30 through
30 to
35.
35, correct.
But that one's a little different than the blanket response that, or argument that I got from the state. And I just want to state for the record that because with the language in Mantelli, as it related to 5191, sometimes not being appropriate when it's justified by homicide by a public officer, it didn't seem appropriate in this case because I think the evidence is clear that they were acting in their lawful duty to arrest. So it's not appropriate for that reason, factual.
Take a 3-minute break.
Yes.
Thank you.
You could take like 10 minutes.
Okay, thank you. Just give me a minute.